Okay, so hello, I'm Sarah Harris, the Managing Editor of the Journal of IP Law and Practice, or JIPLP as we fondly know it. I'm very proud to welcome you today to our 7th webinar. We have an excellent panel here today to discuss enforcement law. We originally conceived this series of webinars as a new way to engage with the JIPLP community and you, our readers, during the pandemic. June seemed a long way off at the outset, but here we all are. It's the 4th of June, and thank you for taking the time to join us today. Today's session will form 2 parts, a brief discussion of COVID-related matters, followed by further analysis of 3 key cases. In addition to all of their other activities, today's speakers are also the co-authors of the JIPLP Enforcement Cases Roundup 2019, which was published just yesterday, and you can find a link in the chat box. On the subject of links, thank you very much to Nora from IPvocate, also a JIPLP author, who will post links to all of the cases during the webinar. A quick word on housekeeping before I introduce the speakers. The webinar will be recorded, and please could all participants mute your mics and videos for the duration. Feel free to post any questions in the chat box, and we hope to respond to those at the end. Now, the speakers. As I said, we have an excellent panel here today. First, from Mauritius, we have Marius Schneider. Marius is the founder and head of IPvocate, a boutique firm with offices in Brussels and Mauritius. Marius has extensive experience of IP enforcement in Europe and Africa. He's the author of several OUP books, most recently with Vanessa Ferguson, Enforcement of IP Rights in Africa, published just last month. Marius is a long-standing supporter of JIPLP and has been consulting editor since 2015. Next, in Belgium, we have Carina Gommers, an experienced IP litigator and partner at Hoynrock Monéger in Brussels. Carina is very active in ECTA. In addition to all that, she's an excellent writer and a long-standing member of the JIPLP editorial board. Last but not least, we have Willem Leppink, who heads the IP team at Plume in the Netherlands. Willem's an active member of Marks. He's also a WIPO domain name panelist and expert, and we'll hear more about that shortly. Willem's a member of the JIPLP editorial board and has been so since the beginning. I'll now hand over to Marius to share some thoughts on the practical consequences of the pandemic on IP enforcement. Marius.
Thank you very much, Sarah. And first of all, also in the name of probably all of us here, thank you very much for the organizers of this seminar, the editorial team of the JIPLP for putting these seminars in place, and for allowing us to engage with the community of JIPLP. So thank you very much. The practical consequences of this pandemic for IP enforcement, well, as it could have been expected, actually, criminals are very agile, and they have adapted very quickly in their trade to exploit this COVID pandemic. So what do we see? We have actually seen over the last weeks and months a rise in substandard and counterfeit face masks, hand sanitizers, gloves, and disinfectants. There has been a very interesting study released by Europol, which we will post in the chat on this. This study really shows how these substandard products threaten the health and safety of frontline workers, but also of ordinary citizens, because they are all available all over. There's also a rise in falsified medicine. A good example is chloroquine. You know that chloroquine was originally a malaria treatment, which has shown initially some good results for this COVID disease, and which has, as you know, also prominent supporters, mainly in the United States. And there is a rise in counterfeit and falsified chloroquine, especially targeting the EU and North American markets where the consumers are. But of course, as it's a malaria medicine, there's also a lot of counterfeit chloroquine around Africa. And in Cameroon, there was falsified chloroquine found in more than 300 hospitals and pharmacies. So really very scary incidents. Who are behind all of this? Well, it's the usual suspects. The production countries are the same as usually, and the modus operandi, the trade routes, and the individuals involved are also the same as usually. These substandard and counterfeit products are available on the darknet, but also on the normal internet. And it is expected that once we will have a vaccine, which is, of course, as you all know, not yet the case, these criminals will move away from the treatments and from the, disinfectants and others and go into vaccines. So that's something that we have to carefully watch. There are already cases of counterfeit vaccines. There has been an arrest in Uganda of a father and a daughter who were administering a counterfeit coronavirus vaccine. What else have we seen? We have seen during the lockdown a shift from consumers to e-commerce platforms with, as a result, of course, an increase of small parcels, very difficult to intercept by the customs authorities. And due to the negative economic consequences of the crisis, consumers are now increasingly looking for bargains. And that is, of course, fueling counterfeiting, but not only counterfeiting, also piracy. People are a lot at home, as you can imagine, so they're going a lot for illegal streaming platforms. Customs enforcement and also police enforcement does not really work. Customs and enforcement authorities work with skeleton staff. So that has led to a dramatic drop in the number of cases all over the EU. And the ECTA Anti-Counterfeiting Committee did a little survey in the committee, and that found out that there's a few exceptions, namely Hungary and Latvia, where there seems to be business as usual when it comes to enforcement. So that's good news. However, there is a moratorium on physical controls in stores, so no more raids are possible for the moment. As far as court hearings are concerned, they are postponed for most of them or suspended, except for urgent cases. And if you can get a decision, then it is very difficult in practice to find a bailiff to enforce it. This is what I wanted to say. Maybe one word on customs training. Customs training, that's of course people gathering together, that these are many times suspended. We inaugurated the practice of doing Zoom customs trainings in Mauritius, and that works quite well. Thank you. Go back to you.
Thank you, Marius. I'd now like to ask Carina, please, to talk to us about COVID and the development of compulsory licensing, the use of compulsory licensing.
Thank you, Sarah. Indeed, that is on the other end of the spectrum. So Marius discussed about the counterfeits and the criminals and the crooks, but on the other side, you have, of course, the innovative business. And also there we have seen issues now with compulsory licensing coming on the foreground of the discussion. And for most of us, certainly also for me, compulsory licensing was this chapter in IP law that you studied in law school, but then afterwards never really put into practice. And now we're here faced with this pandemic, and now it's really a hot topic, a debate on this compulsory licensing. Why is that so? Because of course we have this this race towards the vaccine. We have currently more than 50 clinical trials being led on finding this vaccine. And then, of course, there are questions that arise. When will it be available, the vaccine? But also, how will it be made available? At what cost? At what royalty rate? Where can it be produced? Where will it be produced? And all these questions have turned into the debate on the compulsory licensing. Compulsory licensing, of course, is known throughout the world because it finds its basis in Article 31 of TRIPS. So it's available in many countries. But on the other hand, it's also a procedure that is not efficient in the sense that it is quite cumbersome. Because the first precondition in the normal regime of compulsory licensing is that you, if you want to have this license, you have to show that you have been negotiating with the patentee, and that takes time. And this is, of course, not something that we have at the moment. It also only deals with patents, so it concerns older inventions. It doesn't say anything about patent application. It doesn't say anything about trade secrets and confidential know-how, and you also have the data protection for the regulatory framework. So all these issues, all these questions cannot be answered by turning to compulsory licensing as we know that. And there are also several territorial restrictions which also have to be taken into account. So what we've seen then is that governments have taken it one step further and have tried to enact specific COVID-19 compulsory licensing regimes. For instance, we've seen in France, we've seen in Germany that they enacted specific legislation that give really extraordinary powers to the ministers of health to face this crisis. But then again, also there, not all these issues that I just come to discuss can be resolved by these special measures. So what I think is that there still is a silver lining, not only to be found in this compulsory licensing scheme, but I think on the one hand, you have all this political debate on compulsory licensing, which of course the pharmaceutical companies also follow closely. And on the other side, we also see really an unprecedented form of cooperation between different pharmaceutical companies, between academia and pharmaceutical companies. So I think these two things combined make me hopeful that indeed we will have this vaccine in a shorter time period than we would have for other types of developments of vaccines, and that it will be available at a royalty rate which is reasonable, and it will be made available as widespread as possible. And I've just this afternoon read an article that apparently the Netherlands, Germany, Italy and Spain, if I'm correct, they also will try to organize themselves in the way that they can produce it on a European level to make it available throughout Europe. So I think we can be hopeful, and we should be hopeful that there is this silver lining. That's what I wanted to say.
Excellent. Thank you, Carina, and thank you for ending on such a positive note. We'll now ask Willem to update us on WIPO and domain names. Willem.
Yeah, thank you very much, Sarah, and very good to be with a lot of people in the audience. I saw a lot of familiar names. I hope everyone is still well and in good health. I think this topic is close to heart. I think what Marius already said about the issues surrounding scams is something that I'm very involved in, both from the WIPO end, but also in my role at Marx, being in the anti-scam task force, which normally highly relates to scam invoices. I think I was only home for 1 or 2 days, and then I was contacted by our financial controller at the firm and said, "Why do you give me instructions without giving me the right details?" And I looked at that email that he forwarded to me, and that was an email by someone who impersonated me and asked whether he could just pay some money to that crook. And you see the same happening at the World Intellectual Property Organization, at the Arbitration and Mediation Center in relation to domain names. There are lots of good activities, and you see domain name registrars registering lots of domain names. Also for good purposes for business that is COVID-19 related, but there's obviously also COVID-19 related cyber crime. You see an increase in even in domain name cases compared to the same period last year. So lots of also bad faith filings. Just interesting maybe for you in the group to know is WIPO Arbitration and Mediation Center completely moved their operations to a large extent to work remotely. That still works as normal as it could be. And there have been several interesting cases. Obviously, domain names like Dettol, handsanitizer.com Facebook COVID-19.com. There have been, of course, all kinds of combinations between pharmaceutical companies and combined with the word COVID-19. And obviously there has already been a case about Tokyo 2021 for the Olympics. So lots of the developments there, Sarah.
Thank you, Willem. I'd now like to ask you to introduce the first of our 3 cases. Just so participants know, this is a late 2019 case that is covered in the roundup article that I referred to. So Willem, Spin Master.
Yes, absolutely, Sarah. And this case, Spin Master, was from November 2019 at the CJEU, and originating from the Netherlands, originating as a community design case. And it is all about sort of what is the jurisdiction of national courts other than the designated community design courts. How can they deal with provisional and protective measures, basically provisional measures? And you see in that debate, there's a lot going on about whether this is just a matter of internal jurisdiction. And originally, I think a lot of people did not watch this case that much. Because they said, oh, it's just about designs, and oh, I don't handle that many design cases. But this case is super relevant also in the trademark space, because it applies exactly to the European Union trademark system, as, let's say, the way that the courts are designated are identical. And the interesting bit, and that's with my background interesting to say something about, is that it has ended a big dispute that was going on in the Netherlands, actually between the courts and between several legal scholars on the question whether the EUTM court and also the Community Design Court in The Hague had exclusive jurisdiction also for provisional measures. And in very short, the outcome was that Amsterdam won the game from The Hague. I'm from Rotterdam, so I can say that. But this issue is certainly relevant for the EU as a whole. Just a little bit as background, because if you look at the decision, you think, hey, Spin Master, but it says this strange, for most of you, horribly difficult to pronounce, de procureur-generaal bij de Hoge Raad der Nederlanden. And that's very confusing. And I was, as a student, always a little bit puzzled about all these difficult case names. I still remember all these matters of Regina versus the secretary of whatever ex parte something. And then I always was thinking, who the hell is Regina that is always doing all this litigation? But these are the odd things of, let's say, national litigation. And this was a reference for a preliminary ruling in that case. And this is about the Hoge Raad, which is the Supreme Court of the 4 countries that make up the Kingdom of the Netherlands. And the Procurator General is the general prosecutor that deals with crimes committed by the highest officials in those 4 countries. But it also has a role that is similar to the Advocate General with the CJEU, delivering opinions before the court reaches its decision. And the deputies of that procurator are also called Advocate General, but I guess that they didn't speak about that in the decision, not to confuse the whole situation with the Advocate Generals at the CJEU. As background, for those of you who are maybe not from Europe, the situation is that that according to Article 80 of the Community Design Regulation, there is a system in place, and the same goes for 123 of the EU Trademark Regulation, that cases involving registered community designs, or community designs, better to say, and European trademarks are to be dealt with by specialized courts, first and second instance in each country. And the idea is to limit that as much as possible. So in a country like the Netherlands, but also in France, they have just appointed 1 court for every level, and in the Netherlands that's The Hague, and in France that is Paris. But in Germany, for constitutional reasons, they had to appoint a Landesgericht and an Oberlandesgericht in every land. But it has been said in Article 90, and that's the same as 131 in the EU Trademark Regulation, that for provisional measures, not only that specific court, that expertise court has jurisdiction, but also other courts that have jurisdiction in national design cases or national trademark cases. And the only thing is, if you go to that court, you cannot get an EU-wide injunction. That's only for those specialized courts. In the Benelux system, both for trademarks and designs, all district courts in the Netherlands, and there's something similar in Belgium from what I understood, have jurisdiction. So practical thinking is all those courts would have jurisdiction for those interim measures. But a special situation happened in the Netherlands. The Dutch Implementation Act, which designated the court in The Hague as that expertise court, said it is also exclusively for provisional measures. So in the Netherlands, for a Benelux community, as for a Benelux design right, you could go to any district court, but for the idea of that legislation was that for a provisional measures in relation to community design, you had to go to The Hague. And the people did not agree on that in the Netherlands. And there was this dispute in Amsterdam about a registered community design right. And Spin Master brought proceedings against an alleged infringer, High Five, before the district court in Amsterdam. And that was, of course, not the community design court. Then there were interim injunction proceedings, the famous Dutch kortgeding, which is known for its, let's say, mini trial, but still, as we know from MS, it is those are provisional measures. And the court in Amsterdam, the provisions judge said, I have implementation as the Dutch implementation is contrary to EU law. And he concluded that there was infringement. And then we had the same problem that we always have. None of the parties appealed. So the case ended there and we still had no answer. And then we have an interesting situation. The Procurator General appealed in cassation and brought the case immediately to the Dutch Supreme Court, and said, "I appeal in the name of the law, in the interest of the law, as it is called." And the interesting bit is that this Dutch Advocate General is a former provisional measures judge from The Hague. And he wrote really a beautiful, lengthy opinion. I would wish that it could be translated to every language for others to read, making references to the intended community patent system, to the EU trademark rights regulation, literature, or even mentioning the Oxford University Press book from David Stone. And he was saying, I'm in favor of this exclusive jurisdiction in The Hague. That's better because then you have a specialized court. And then he said, well, but I think the Supreme Court should refer this matter to Luxembourg. And then the question was raised: can member states actually limit the number of courts that can deal with provisional measures? And then the Supreme Court made that reference to the CJEU. And first of all, and that was, I think, interesting in general for us, was that the CJEU first looked at the question, can you look at a matter if it's in the interest of the law? Because there's not an actual dispute anymore between the parties. And but I think the Dutch government also supported that view. And then the CJEU took quite a broad interpretation and said, well, these are still proceedings, and if it's proceedings, then you could do that. So that is all fine. The Dutch government also said, well, we support the Advocate General, the Procurator General, in relation to this idea of just doing The Hague, because that was also the Dutch legislation. And then the CJEU said, no, this is completely wrong. This is not an internal matter which court has jurisdiction, because you have to follow the text of the Community Design Regulation or the EU Trademark Regulation. And the establishment of the specialized courts was really relevant for uniform application of this right. And that relates then to matters on the substance, thinking about infringement and validity. But the whole idea of the EU legislature was to be able in an efficient way to go to any court around the country that would normally also be competent to hear a normal interim, a national rights case, so in the Benelux, a Benelux case. And the most important goal there is to stop the infringement, cessation of the infringement. So they did not agree, and they said no. All the other national design courts will have jurisdiction, albeit limited to their country, and that I think is really relevant. Case went back to the Netherlands. Procurator General said, well, you know, a new opinion. I've heard what the CJEU said. Please deny my appeal, and that's what the Supreme Court did. I think just a little bit as background, and would love to hear from Marius how he looks at this. The kort geding, the mini trial in the Netherlands, is of course by nature, and that's how it got started, much more something separate. Like I said, it's a mini trial. It is a different story from let's say just asking for getting a signature under a seizure request. And the problem is that in these inter partes proceedings, you will get a discussion about validity, and but at the same time, and that's I think my concern, and that's why you understand the debate that's going on. Yeah, if you concentrate all your cases in one court, what do you do if you, for example, get a criminal case about trademark or design infringement before another court? Because that court, there will hardly be anybody doing IP. There will only be rare instances that people will have a Benelux design and not an EU design anymore. So yeah, how to deal with that? But I don't know, Marius, whether you want to say something about that.
Yes, Willem, thank you. I fully agree. When you first came up with this case, I thought, well, this is all a very doctrinal discussion. But actually, it has a lot of practical implications for us practitioners, because it should not be forgotten that it does not only apply, as you rightly said, to EU designs, but also to EU trademarks. And so that widens the scope quite a bit. And as you rightly said, it leaves the possibility now to go a little bit for forum shopping for provisional measures, which can be a mini trial. And it is surprising, actually, that the Court of Justice of the European Union, in this dichotomy between proximity and specialization, has chosen for proximity. It's surprising, actually, because one would have thought that they go for the specialized courts and the very limited number of courts. Now, well, one thing that I'm asking myself is whether this COVID-19 crisis has actually changed our perspective about all of this, whether, the last 6 months or the last 3 months we went through, 6 months since that decision, actually, whether there hasn't been a fundamental change. And I just used the keyword, Zoom trials. Yeah. And as you've probably seen, the EU IPO just announced that the Board of Appeals can now hold video trials. So, and in Nigeria, somebody has been condemned to death by a Zoom trial. So, the better and the worse, if I may say so.
Yeah, absolutely.
So all of this may have changed our perception, and shouldn't be forgotten that EU trademark and EU design law is getting increasingly complex. And your point as well about the criminal trial is very pertinent, because these are proximity courts who hear these cases, and as a practitioner, I notice oftentimes that the judge, and oftentimes also the defense lawyer, is not so well prepared to argue the subtleties of IP law, but which oftentimes plays in the favor of the right holder. So I'm not going to complain about that. But as you rightly say, most cases involve national and EU rights, and therefore my question is whether the silver bullet would not be to have a very limited number of IP specialized courts competent to hear both national and EU cases, thereby creating a balance between true specialization and proximity.
Yeah, I think that I hear now a good story. I just read here on the chat from Bartos that in Poland there will be 4 different courts, and they will sort of bring it in line that those will be the designated courts for the EU TM and the CD, and at the same time for the national rights. So that's also an approach, because you also tend to hear that just having one court of first instance also makes the system quite rusty, because all the judges speak with them amongst themselves when having a coffee when they're back in court, and may end up with the sort of the same decisions all the time, which is also not good for the development of the law. But last but not least, what a quick note here from my end. I think this is just a starting point. I think there will be more to happen. We had lots of clients asking about seniority claims, because as you know, in the system of the EU trademark regulation, you can give up your national rights and you can just add it as a seniority claim to your EU trademark rights. And it has been said that you will keep exactly the same rights as you had with your national rights. And this is a complicated story, because if I have given up as a trademark owner, my Benelux trademark right, and then just pushed it as a seniority right under the EU trademark rights, can I still go to that court that only is allowed to deal with Benelux rights, and ask them for a court decision, even on the merits relating to just the Dutch or the Benelux territory? And I think there's a lot of issues where this will have consequences, but we'll see. But I'm conscious of the time, so I'm handing back to you, Sarah. Thank you.
Thank you. Thanks. So, Marius, are you happy to introduce our next case from 2020? And I think you might have a few props to share with us.
Exactly, thank you. So I'm talking about the Court of Justice of the European Union case 772 from 2018, but handed down only a month ago. And that is Company A against Mr. B. It's a criminal case, so the names of the parties have been anonymized. The request arises it's a preliminary ruling on the concept of use in the course of trade, and the issue arose in proceedings between Company A against Mr. B concerning a criminal trademark infringement action brought against Mr. B. So what were the facts? Very important to analyze that briefly. Mr. B is a natural person, a resident of Finland. He received from China a consignment of 115 bearings weighing a total of 710 kilos, so not a small parcel. On the bearings, a trademark belonging to Company A was affixed. Customs clearance was completed in the name of B, and B withdrew the consignment from the customs warehouse, took it to his home, and stored it for a little while. A few weeks later, he delivered the bearings to a third party, and they were exported to Russia. B received as remuneration for those services a carton of cigarettes and a bottle of brandy. You have to know that bearings, and I have some here, bearings are security relevant industrial spare parts, these little things, used in transmission mechanisms, in generators, engine, tramways, but also for the construction of bridges. And as I say, these are really little things, but security relevant. A failing bearing can have dramatic consequences for the health and safety of the user of the product. So that's quite important to keep in mind. Criminal proceedings were engaged against Mr. B for trademark infringement. In first instance, the court acquitted Mr. B because it was not proven that he had deliberately committed the offense. But B was ordered to pay damages to A, and that was enough for B to go and appeal the decision. The Court of Appeal noted that the activity of storage and onward transport was carried out without the objective to obtain any economic benefit. The remuneration, the famous bottle of brandy and the carton of cigarettes, is not based on economic exploitation of the goods, but merely a consideration for the storage. Hence, there was no use in the course of trade, according to the Court of Appeal of Helsinki. Parties were not content. The matter came to the Finnish Supreme Court, and the Finnish Supreme Court also was not certain whether there was use in the course of trade, and asked itself quite a lot of questions. It asked, for example, is the amount of the remuneration received at all relevant? Can it be qualified as importation when the goods are not imported at the person's request, but the person merely provides an address to a dealer and the person acts on behalf of that dealer? And because of all these questions, the Supreme Court of Finland put a preliminary ruling to the Court of Justice of the European Union. Court of Justice received the questions, 4 questions altogether, and as usually rephrased the 4 questions into one question, and that question reads as follows: is there use in the course of trade if a person who does not engage in trade as an occupation takes delivery of, releases for free circulation in a member state, and retain goods that are manifestly not intended for private use, when these goods sent to that person's address are sent from a third country and bear a trademark without the authorization of the holder? That was the question that the court said it needed to answer. The court reminded us that exclusive rights may only be relied on against economic operators in the context of a trading business, and that there is use in the course of trade only if transactions are carried out and go beyond the scope of a private activity by reasons of their volume, their frequency, and other characteristics. And based on that, the court infers from the circumstances of the case that 710 kilogram of bearings generally used in heavy industry are by their nature and volume not intended for private use. So here we have it, no private use for the 710 kilogram of these little bearings used in complicated appliances. The court confirms that there is import if a person makes known his address and the place to which the goods can be delivered, completes or has completed through a customs agent the clearance of the goods, and releases the goods for free circulation. So these are the circumstances under which there is clearly import. So you make the customs declaration yourself or through a customs agent, specialized customs agent, and then it's import. So actually the court made it quite easy to quickly conclude that in this particular case, the goods were really imported by Mr. B, and the court didn't really go any further, and that's maybe a little bit of a pity, because there's many other questions one could have addressed in the framework of this case. The court only reminds us, and rightly so, that the ownership of the goods on which the trademark is affixed is of no relevance, and so is the significance of the revenue that is paid against these services. So altogether, I think this is a very interesting decision, and it's quite an important sign to criminal organizations who use private individuals to import infringing goods to cover up their traces. Because that is what really happens, is that people like Mr. B help criminal organizations to constantly change their routes by constantly picking new Mr. Bs, and to make it more difficult for right holders to trace the activities of the organization who is behind it. So I think as a way of conclusion, one can say that it's a very important and welcome signal that the Court of Justice has given in this decision. And Carina, I think both of us were immediately reminded a little bit. It's quite a political question. The court couldn't let Mr. B off the hook, and in that it reminded me of our case Rolex against Mr. Blomqvist, who could also not be left off the hook.
Yes, indeed, Marius. The other Mr. B, indeed, Mr. Blomqvist, a couple of years ago, I think it must have been 2013, 2014, when we had this case where the Danish customs seized a counterfeit Rolex watch, which Mr. Blomqvist had ordered from a Chinese web shop. And there was this issue that he was a private person and he bought that on this Chinese web shop. And here what is interesting is that the court in the recent case says that there is use in the course of trade if the transactions carry out go beyond the scope of private activity, and then they refer to the volume and the frequency and these other types of characteristics. But actually in the Rolex case, they went even further than that, and they said, well, it is a private person, and that's not relevant. It still is a counterfeit watch that can be seized. Of course, there the import was done on Mr. Blomqvist's own behalf. He bought it for himself. He did not have any financial benefit or an intention to sell it further. But I think both decisions really show that you have these far-reaching decisions where the Court of Justice really in favor of right holders and interprets the customer regulation quite broadly. So indeed, to be able to act against these criminals and crooks, as you rightfully characterize them.
Yes.
Thank you, Carina. Thank you. Are you happy now, Carina, to move on to Coty Amazon?
Yes.
Sorry, I was just going to say that you've already written about this and we'll post a link in the chat box. Go ahead.
Yes, thanks, Sarah. Another thing actually was in the A and B case was the storage of the goods in the offline world, and they referred to this top logistics judgment. And that brings us actually to the last case that we'll discuss today, which is the Coty Amazon case. Which moves us from storage in the offline world to liability in the online world for storage and more actually than that, although that is precisely the topic of the debate. So this is the last judgment that we will be discussing today, and it concerns the services that Amazon has qualified as their fulfillment program. So Amazon, when users use this fulfillment program, the seller does not only have the possibility to offer its goods for sale on the platform, but Amazon provides the seller with a whole range of other services, among which storage of these goods, promotion regarding the goods, shipment of the goods, and even after sale services. So it is a program that has far-reaching consequences, but the court did not take all that into account, and I will come back to that later. First, I wanted to address very briefly the facts of the case. So you have Coty on the one side, who is holder of the Davidoff trademarks for perfume bottles, and they made a test purchase on Amazon. The test purchase of these perfume bottles appeared to be infringing, and they contacted the seller. So in first instance, they had this contact with the seller directly and not with Amazon. The seller acknowledged, they came to a settlement, and the seller signed a cease and desist declaration. Then in a second step, Coty asked Amazon to send to it all the stock that they had from this seller in storage. And so indeed, Amazon followed up. Amazon sent 30 bottles of perfume to Coty. Sometime later, another Amazon entity said, well, hold on, from these 30 bottles, we've now been able to identify that 11 of those bottles are actually not from this seller, but from another seller. To which Coty responded, well, we've tested and we've examined all these 30 bottles, and actually 29 of them are infringing. So if you now say that 11 bottles are not from this seller, but from another seller, this other seller is also infringing our trademarks. So please give us the contact data, give us the name and the address. To which Amazon responded that they were not in a possibility to give up that information. So then Coty initiated proceedings in Germany against Amazon for direct liability for trademark infringement. In first instance, an appeal they lost, and the case was then heard before the Federal Court of Justice, and the Federal Court of Justice did indeed refer the question to Luxembourg, referred the case to Luxembourg, to also know, as in Marius' case, what is to be understood as use of the trademark in the course of trade. However, it is very important, it's very important to know that this question was really narrowly formulated by the Federal Court of Justice towards the Court of Justice in Luxembourg. So I'm going to read the question because it's really important how they have formulated it. So they say, does a person who, so this is Amazon, on behalf of a third party stores goods which infringe trademark rights without having knowledge of that infringement, stock those goods for the purpose of offering them or putting them on the market if it is not that person himself, so Amazon, but rather the third party alone which intends to offer the goods or put them on the market. So you have the first condition that Amazon is only storing the goods on behalf of another person. So there is no mention of all these other services provided by Amazon. So only storing the goods. Secondly, they qualify that Amazon does not have knowledge about the infringement. And the third condition is that this third party, so the seller, the actual seller, he alone intends to offer goods, to offer the goods or put them on the market. So this is the question that the Court of Justice had to work with. And of course, Coty was not very happy with this question and this narrow definition, and they tried to convince the court to take into account a more elaborate factual setting and a more elaborate question to really also be in line with what in reality happens. But the court denied that. The court said, no, this is the question that has been referred and I will only take this question into account. So then we come to the ruling of the court, and indeed it rules about use of the trademark in the course of trade. And there it first acknowledges that indeed it is a non-exhaustive list, but nevertheless, you need active behavior and you need an either indirect or direct control over these acts. Then it turns to the facts of the case, and it refers back to its older judgments, specifically in the online world, the judgments that we all know very well, the Google one from 2010 and the eBay one from 2011. In the Google case, it had already decided that there was no use in the course of trade by Google when Google developed this AdWords service. And in eBay, it had already decided that there was no use in the course of trade for eBay when it delivers this space online, when it provides this platform for sales, and only when it does so. It goes then further, the Court of Justice, it leaves the online world and it goes to the offline world, referring to the Winters judgment and the Top Logistics judgment. And there it also says also these types of services that are provided on behalf of a third party cannot qualify as use of the trademark. So in Winters, it was relating to filling of cans, of soda cans, and in Top Logistics, it was the storage of the goods. And that brings us from the offline back to the online world. And indeed, following its logic in Top Logistics, it then concludes that indeed the mere storage of the goods under the preconditions of the question as referred do not constitute use of the trademark. It says further that the storage would only be used when Amazon itself pursues the offering of the goods or putting them on the market. And the facts described did not allow it to establish that. So for a lot of people, this was a disappointing judgment. But I think that not all is lost. You have, after it has made this decision and this ruling on what qualifies as use of a trademark, it refers itself to the Enforcement Directive and the E-commerce Directive, where you can have injunctions against intermediaries. And it also says that, of course, Amazon for its own sales is liable or can be held liable, but also for sales where it is impossible or when Amazon itself cannot identify the seller. So there, I think there are still some possibilities after this judgment, although for many people indeed disappointing. But I think there is also another possibility that in the future we will have another question referred back to Luxembourg actually describing what Amazon does. And if that will be the case, of course, they can look back to what the Advocate General has said, and he has taken those facts and those services in a broader scope into account. So that would be interesting to see if such a case would in the future come up back in Luxembourg. Marius,
Yeah.
you think that that against intermediaries are the way forward?
It's Willem who should answer you, but yeah.
No, but go ahead, Marius. You first. No, you go first, Marius.
You go ahead. No. Of course, yeah. There are a lot of possibilities against intermediaries, so yeah, it's a good idea to make use of that. Absolutely.
I think a little bit of the disappointment of the case is that you typically see how this is all being, let's say, translated into the press. You know, I think that a lot of trademark owners were very happy to read what the Advocate General said, and said, well, this is very subtle, you know, goes into the details, makes a clear distinguish between someone having just a storage facility and Amazon. And the problem is that although the judgment of the CJEU does not say it explicitly, it is interpreted by many in the general press as Amazon is not liable, sort of period. And I think that is absolutely a wrong conclusion. I think it all had to do, like you said, it is the question that was posed to the CJEU. And indeed, I completely understand how the CJEU had to decide that case. But it is, I think the problem is, and I do not know whether that has to do with, let's say, the more competition law background of the court in Luxembourg. It is, I think it is just not, it gives an answer to a situation which is not the actual situation. We have a party, Amazon in this respect, handling fulfillment by Amazon, and having a situation where they more or less do everything. The only thing is that the financial burden of buying, as I say, buying the product is done by the actual seller on Amazon, and the seller carries the financial risk. But for the rest, everything is done by Amazon. Amazon stores it, Amazon packs it, Amazon sells it online, and Amazon ships it. They do everything. And still, in that respect, Amazon is not using the trademark. And you know, and you can look, of course, on let's say how this legal approach is. But if you look at that, it is a little bit strange. The one thing is and I'm quite passionate about it, sort of how this CJEU works towards a sort of favorable outcome, which you also saw in the Mitsubishi case, that certainly not using a trademark became using a trademark. And here we have someone that is doing all the typical things that are trademark related, and that it suddenly is no longer trademark use. And I think and I think you were absolutely right in saying that, Carina. I think that going forward, there will be a next question, because one of the things I think a lot of people do not realize, this situation, let's say, what Amazon actually does. I think we've spoken about that before. A lot of people have questions. They say, huh? How is this happening? We sent them a cease and desist letter and they say they have more. How is that possible? Because they are storing those products for that seller and they're passing it on. How can they have more? Now the reality is, and a lot of people do not know that, is that Amazon stores all the products with the same barcode, and in the end they translate that into an ASIN code. They all store them in the same place, and so they have in their storage facility different, let's say, products from different sources, but that are identical. So there are 20 products from one seller, 20 products from another seller, and 20 products from a third seller. And because they all have the same barcodes, but could be legal parallel trade and illegal parallel trade, then those products are actually just mixed up when they're being sold. And that is so in the end, Amazon is also not able to trace exactly whether that legal parallel trade went to someone or the illegal parallel trade went to someone. So in my view, there is still a bigger role for Amazon here, but it's a pity that that you get a decision which is, let's say, maybe a right decision as such, but is still not right in relation to Amazon.
Thank you, Willem. I must say, when you mentioned the other day that that's how Amazon managed its stock, I was quite shocked. It's certainly something I didn't know about before. Oh. We've got about 4 or 5 minutes left, so I can see that you've been responding to some of the questions as we've gone along. I wondered, Carina, whether you wanted to respond to this comment really from Mayank, saying it's interesting that Coty did not invoke the enforcement directive to request the names of the counterfeit suppliers. Same wording as Mitsubishi and Duma active conduct.
Well, I don't know all the facts of the underlying case in Germany, but I do know that they themselves referred as well to the enforcement directive and the e-commerce directive in Luxembourg when the case was in Luxembourg. So they probably did ask for that information. But as Willem said, since they organized themselves in storing all these goods intermixed with each other, and also if you see how it's written in the judgment, it doesn't say that Amazon refused to give the data. They say that they were impossible to comply therewith. So they themselves apparently do not know where these goods are or from which sellers precisely they are. So I think that was the problem. Because I do think, as I said as well, that both the enforcement directive and the e-commerce directive give possibilities in the sense of having an injunction without liability. So for the moment, I think that is still the way forward.
Thank you. I've just got one more question. I wondered whether Marius and Willem would like to spend 1 minute each on whether you think that the current pandemic, this is back to the earlier part of your discussion, whether you think that the current pandemic will have a lasting effect on the functioning of the IP system. It's a big question, but maybe 1 minute each. Marius, would you like to go first?
Yes, thank you. Well, I think we already start to see some effects. I mean, countries are quickly to organize these solutions for compulsory licensing, and also we see cases where in some countries where there's no patent protection, they just start to produce. I was just reading about producer in Bangladesh starting to, without any license, produce remdesivir in big quantities, whereas in India and Bangladesh you have licensed producers of remdesivir, but as there is no patent protection apparently in Bangladesh in place, so they can just go ahead and then deliver it to the countries where there's no patent protection. So yeah, well, that's one thing. Then, as I said, the video trials, that will certainly be something, and you see the EU Board of Appeal has said that they will introduce that possibility, and that's going to last. But I think, you know, in our, and of course we've seen now conferences, entire conference organizers moving online, so you will have an online INTA. But I think that is not something that will hopefully at least stay, because in our business it's quite important that you meet your colleagues. You know, if you have to work with a colleague, in my case, somewhere in an African country, and you never meet these people, that cannot work. You know, we can only work together if we have confidence in each other, if we know each other, if we have trust in each other, and for that we need to see each other. So that's hopefully a change that will not last, but many of the other changes, well, they will be around. Yes, I think so.
Thank you. And Willem, 1 minute for you.
Yeah, absolutely. Very briefly, I think that the Coty case really shows the significance of e-commerce. And I think this is going to be a big battle. You see that, let's say, what I call the competition professors in Kirchberg in Luxembourg are very happy to see that, let's say, consumers get this transparent market, which seems to be transparent to them, in which sellers fight for the price and in the end bring a good result to the consumers. But at the same time, it's also going to be a clash with the interest in Europe of, let's say, selective distribution systems, regular distribution systems. This is, to a certain extent, probably the end to the bricks and mortar businesses, and that is also one of the sort of cornerstones of let's say our economic infrastructure in Europe. So I think in the end, what the CJEU has to do is quite political, and I think there will be more players. So not only on what we used to have on the data protection side, but also here on the distribution side, it's going to be political, and it's going to be the tech giants against, let's say, the industry interests.
Absolutely. Well, thank you all. That was absolutely great. Thank you. And thank you to all of the participants again for watching. Yeah. Do feel free to connect with any of us via LinkedIn. My details are also on the journal website. And as I always say, don't forget that we're always on the lookout for new submissions. Thank you.
Absolutely. Thank you for leading, Sarah.
Thank you, Sarah.
Okay. Thanks.
Bye-bye.
Bye.
All the best. Bye-bye.
Bye.